Mm. Okay, good morning and good afternoon to all the participants joining us today. Welcome to the IP Mediation Seminar. This is an activity organized by SCOPE IPR and organized in coordination with ASEAN IP Academy. SCOPE IPR is a project funded by the European Union and administrated and implemented by the EUIPO. And this webinar brings together ASEAN and EU experts to share best practices, insights, and recent developments in the field of IP mediation, a vital tool in resolving IP-related disputes in an efficient, flexible, and confidential manner. Let me by introducing Karin Kuhl, which is my former boss from the trademark and design department, the operations department, and now the director of the EUIPO Mediation Center, who will share the opening remarks on behalf of the European Union Intellectual Property Office. Thank you, Karin.
Thank you, Gonzalo. Good afternoon to our Asian participants, and good morning to those like me joining from Alicante. I'm Karin Kuhl, Director of the EUIPO Mediation Center. I've been in this role now for nearly a year and have gained significant insights into IP mediation. Previously, I directed the EUIPO Operations Department, managing trademarks and design rights tasks, including proceedings such as opposition and cancellation proceedings. All those procedures have in common with mediation that they are all inter partes. They are also fundamentally different. Mediation emphasizes on business interests, not necessarily so much legal interests. In addition, human aspects and emotions play a key role in mediations. They are elements that are not typically addressed in official trademark and design decisions. This human focus is why events like the SCOPE IPR Mediation Seminar are vital for sharing experiences and enhancing our mediation services. For the EUIPO, learning from Asian colleagues is crucial, as many users from your region increasingly now prefer mediation for pending IP disputes before the EUIPO. They can include in the scope of mediation any other dispute pending in any other jurisdiction anywhere in the world. Moreover, they can benefit from our services at no additional costs. Today's seminar is the first SCOPE IPR activity this year, directed by the European Commission and administered by the EUIPO. The SCOPE IPR project supports Asian member states in harmonizing IP practicing and fostering cooperation. At the last Asian mediation workshop held in Manila in November, we learned a lot about some very interesting initiatives in IP mediation adopted by the Southeast Asian countries. Examples include mediation prior to actually IP disputes, subsidized mediation initiatives, and coverage of multiple IP disputes lodged before different countries in ASEAN. We used some of your approaches and as inspiration for our revision of our mediation framework here at the EUIPO in order to streamline our processes. My colleague Goran will tell you more about this during the first agenda point. However, since the best way to learn is to share practical experiences and best practices, in today's webinar, we will devote more time to learning from the experiences of experts from Asian countries and the EUIPO Mediation Center. The discussions during today's webinar will serve as input for future SCOPE IPR activities on mediation, with the aim of further improving the quality and accessibility of IP mediation services available for businesses, including SMEs, in the Asian countries. We would like to thank the Asian IP offices, the ASEAN Secretariat, and the Asian IP Academy for collaborating with the EUIPO within the framework of the SCOPE IPR project in making this webinar possible. The European Union remains committed to providing support and continuing the strong cooperation with ASEAN as we continue to address the challenges of IPR protection and enforcement through more cost-effective, speedy, and efficient dispute resolution mechanisms. I thank you for your attention and wish you a very fruitful seminar with great discussions and exchanges. Thank you.
Thank you, Karin. Now I'm pleased to welcome Dr. Tam Luong, who will speak on behalf of ASEAN Secretariat. He's the Assistant Director for the Marketing Integration Directorate and Head of IPR. Nice to see you, Mr. Dan.
Thank you, Gonzalo. Ms. Karin Kuhl, Director of the EUIPO Mediation Center. My friend, Mr. Gonzalo Bilbao, Project Leader for Southeast Asia of the EUIPO. Distinguished participants from ASEAN family, esteemed speakers. Very good afternoon from Jakarta. As introduced by Gonzalo, I'm Tam Luong. I'm Assistant Director of the Market Integration Directorate, overseeing IPR. It's really a pleasure for me to join you today at this important webinar on IP mediation under the SCOPE IPR project. Let me express my sincere thanks to Ms. Karin Kuhl and the EUIPO Mediation Centers for their continued partnership, and Mr. Gonzalo Bilbao and SCOPE IPR team for your excellent coordination in bringing us together for this important exchange. I also thank my ASEAN colleagues for your presence and commitment. Today's webinar marks timely and valuable opportunities to explore how intellectual property mediation is evolving in the European Union and ASEAN, and how we can work together to further integrate mediation into our IP ecosystems. We all recognize that the protections and enforcement of IP rights are critical to fostering innovation, creativity, and investment in our regions. Yet enforcement is not only about litigation. The ability to resolve disputes efficiently, cost-effectively, and amicably is becoming more important than ever, particularly for SMEs who may not have time or resources to pursue lengthy court proceedings. In ASEAN, as we move toward deeper market integration, many businesses operate across borders. The diversities of legal systems across our regions can add complexities to dispute resolution. That is where mediation plays a crucial role. It is confidential, faster, less adversarial, and better suited for preserving business relationships and ensuring continuity. More importantly, it empowers parties to maintain control over outcomes and more forward constructively. One promising ASEAN initiative worth noting is the mediation program we call AMP+, piloted in Singapore, which supports mediation efforts for ASEAN companies with the backing of international partners. With co-funding available and flexible modalities such as online and deal mediation, this program has seen a 100% success rate from 2023 to 2024. It showcases the tangible impacts of accessible, business-oriented mediation and could offer aspiration for similar efforts across the region. Ladies and gentlemen, this webinar highlights the deepening collaboration between ASEAN and European Union in building more effective, accessible, and business-friendly IP systems. Through initiatives like the SCOPE IPR projects, we are not only exchanging technical expertise, but also cultivating a shared vision for how IP frameworks can better serve our innovators, businesses, investors, and our economies. A key part of our vision is ensuring that disputes can be resolved efficiently, fairly, and with minimum disruption to businesses' operations. IP mediation is a powerful tool in achieving that goal. In ASEAN, we see mediation as a strategic complement to our broader work of regional IP enforcement. As ASEAN moves toward greater regional integration and digital transformation, it's crucial that our IP legal and regulatory ecosystems, including dispute resolution, keep pace with the needs of our business communities. Ladies and gentlemen, with that, let me thank the EUIPO for convening us today. The EUIPO plays an important role in supporting the enhancements of the IP landscape in ASEAN, and the SCOPE IPR project is of particular significance to our ASEAN IP agenda. We look forward to continuing and deepening this collaboration with EUIPO and our other partners in the time ahead. So with that, I thank you once again for your presence, sharing, and collaborations. And I wish you all a successful webinar. Thank you very much.
Thank you very much, Mr. Tan. And now let's move forward. It's a pleasure for me to introduce Goran Marjanovic. He's also from the EUIPO Court of Appeal Mediation Center also, and he will provide an overview of the European Union's approach on IP mediation and share key practices from the EUIPO Mediation Center. Goran Marjanovic is an accredited mediator and has over 10 years experience at the EUIPO. where he handled legal matters, litigation, international cooperation, and institutional relations. Goran was the project manager for establishing the EUIPO Mediation Center and also serves as mediation case handler, mediator, and speaker at events concerning IP mediation. Thank you, Goran. I pass it to you now.
Thank you very much, Gonzalo, and good afternoon to all of the participants that are connecting from the ASEAN region. I know it's starting to be a bit late in the afternoon for you, but we're very excited to be connected with you, and we hope that you will also enjoy participating in this webinar today. Now, I had the honor of being with a number of the ASEAN colleagues that work on IP mediation in Manila recently in November. And it was a wonderful experience because we had about 2 days together in which we shared a lot of different information and best practices. And I think we all learned a lot. I know I can say I did. So one of the things we learned during this seminar in Manila is that we're already quite advanced on the basic principles of mediation and intellectual property. So what we had talked about at that time was to rather focus on sharing best practices and even examples of mediations, whether they were successful or not, but so that we can all learn from the experiences. Now, we'd like to spend most of the time focusing on that today, as you could see from the agenda. But firstly, if you would allow me to briefly present to you on the latest developments at the EUIPO Mediation Center, I would be very grateful for that. So I will begin this now. And with that, like I said, I'm going to skip basics concerning our services and concerning mediation in IP, and I'm just going to give you a very brief background of what's been going on at the EUIPO. You remember, if you've connected with us over the past couple of years, that we actually established the Mediation Center officially and formally less than 2 years ago in November of 2023. We have, however, at the Boards of Appeal, been offering mediation services for over 13 years now. And it was the establishment that basically formalized these services under a mediation center. Now, what we've done is rather than directly offering mediation services to all different proceedings in one go with the establishment, we phased in the offer of mediation services in different inter partes proceedings. When the Mediation Center was launched, we started off with appeals, so second instance inter partes proceedings. And in July of 2024, we expanded into EUTM, so trademark cancellation proceedings. Now we're going into our final expansion phase, which is going to happen this summer by the end of Q2. And this will include those other two types of proceedings that we have not yet offered mediation services in. They are trademark oppositions and design invalidities. Okay. With that, we see that there's already been an increasing volume of mediations, which I'll talk about. And this has given us a lot of insight and a lot of information about how to revise our rules of mediation, as well as the processes behind it, which is something Ms. Karin mentioned in her opening remarks. So as I mentioned, you see a bit by the numbers the impact of the establishment of the Mediation Center and of moving into different inter partes proceedings, because starting with the early years of 2012, there was a very minimal volume of mediations at the office. The light blue color shows the number of mediations, and the dark blue color shows the number of cases covered by those mediations, because as you know, you can have one mediation that covers 10 different inter partes proceedings at the same time, for instance. You see that also in In 2021, already leading up to the launching of the Mediation Center, we sort of peaked in comparison to all the other years. We had quite a high volume of mediations, which indicated actually that that we needed to keep working on our process efficiency, because the following year it went down. That was the year just before the launching of the Mediation Center. With the launch of the Mediation Center, the numbers started peaking again, and you can see that in 2024, well, we've had a record year. This is set to continue because early on already in this year, we're already at a high number of mediations. So we think that as we open up to oppositions and design invalidities, these numbers are going to keep growing. And that's why we need to revise our process to make it as efficient as it can possibly be. I also need to mention here that the settlement rate, as it's a moving number, but on average, it's at around 70%, meaning that users of our mediation services have a pretty high chance or pretty high assurance that their dispute will settle. Also, the user satisfaction has been at over 80%. So users seem satisfied with our services. Now, in order to streamline the mediation process, as we mentioned, to make it efficient, not only for the users, but also for ourselves as the administrators of the services, we started trying to identify where we could improve. So we looked into bottlenecks in the sense of what stages of the process do parties seem to get hung up, or does the mediation center seem to get hung up, or unnecessary formalities. Are we asking the participants in the mediation to do something that formally is not really needed? We also realized that in the events that we propose mediation to parties and then they need to agree, it takes about 2 months for this to happen, which is quite long. So to see whether there's any way of shortening that. We do have a statutory limit in the EU trademark regulation of 20 days for the parties to appoint a mediator, which also is quite long. And that's something we're not really able to change from a legal perspective, but we could maybe incentivize the parties to react sooner than 20 days. We also noticed some time could be lost in the signing of the mediation agreement, which is a formality, and sometimes getting the parties together to the mediation day so that they can all participate in the same meeting can take quite a bit of administrative effort to set it up. So what did we do with that? We actually developed some guiding principles on how the mediation process can be designed in order to reflect this aim of efficiency and faster resolution than decision-taking process. And indeed, that's the first point, that it should at least be as fast as the formal decision. It should not be slower. Okay, sometimes the parties we've seen, they take a lot of time because they know they have the proceedings suspended, and it's up to the mediation center and the mediators to keep the motivation going so that the parties resolve their dispute quicker than they would have received the decision. This is why we need clear timelines and structured procedures, and it's precisely the goal of our revision. We have to standardize all of the key elements. It relates a lot to predictability for the parties, so they know what's going to happen next in the process. And we really need to reduce unnecessary decision and input points, because this is where we've seen a lot of the bottlenecks, as I mentioned, or delays can happen. So with that, we're trying to optimize our process and structure the approach to the different case exits, really making sure that if the mediator, for example, sees that the mediation is unlikely to settle successfully, that the mediator themselves, they have the possibility to end the mediation so that the parties and the office are not spending too much time on a mediation that's unlikely to be successful. So with that, you can see a bit the visual of our process. And what we're trying to do with this visual is we're trying to introduce a maximum 2-week rule for each of these steps in the mediation process that you see on the screen, meaning that, you know, from the mediation request to the appointment of the mediator, not more than 2 weeks should go by. The same from the appointment of the mediator to the mediation should not be more than 2 weeks. And with that, we're hoping that we could actually cover the entire mediation service in about no longer than 3 months. Now, we say this as a general standard rule. Of course, in certain situations, if the parties are having some administrative issues with complying with the different stages, that of course they would get more time, but the goal is what you see on the screen. So, and some of the things that we've thought about, we actually learned from you, and we thank you very much for this. We remember from the Malaysian presentation in Manila that in Malaysia, the 2 mediation request forms jointly actually constitute the mediation agreement. So we're looking into this direction as well to see if perhaps we can make things easier by spending less time on the mediation agreement, and just making sure that with the request forms, the parties actually already agree to the rules on mediation and all of the confidentiality requirements that are involved in. And naturally, we would hope that therefore the proceedings would be resumed in about 3 months' time, so that the parties could undertake all of the necessary formalities before the office, which would be withdrawing of the formal proceedings and the resumption of the case. Okay, so now, what else do we need to do in order to make sure that our mediation services are working well across all different inter partes proceedings? Well, we need to make sure that we have very close collaboration between the different decision-taking instances at the office. So with that, we've launched a new initiative where the members of the EUIPO Mediation Center, that's the EMC, are working closely together with trademark examiners at the first instance. And we are focusing on different procedural aspects, again, to make sure that we can streamline the process as much as possible. We need to make sure that all of the work instructions and the templates are harmonized across the office. And of course, we continue with the promotion of mediation services. So what we're doing in this case, in collaboration with colleagues from first instances, we're actually obtaining regular extractions of cases with different characteristics that are suitable for mediation, and we're proactively contacting the representatives of the parties in such cases to see if they would be interested in mediating. So examples of these criteria for extracting cases include multiple proceedings, national rights, bad faith, and marks filed by an agent. Basically, many of the cases were either by volume or by the fact that they might be international in nature, we are considering as suitable for mediation because mediation might make things easier for the parties. Okay, and finally, before we move on to the next part, I'd just like to, in case you haven't heard about it, invite you all to register for our next IP Mediation Conference, which will take place on 16 and 17 of October. It's going to be in Valletta, which is the capital of a small European country called Malta. And but it's also available online in hybrid format. It's true that maybe for the ASEAN colleagues, it will be a bit late in the evening, but we hope that if you have time on the 16th and 17th of October, you could register and join us for this event. Okay. So that would take us basically to the end of my update on new developments. So what I would do now, if it's okay with everyone, is that I would move on to the sharing mediation experiences and best practices panel. Okay. And here, what the idea is that we basically do a round table that every speaker from those speakers below that you could see, and thank you, by the way, to all of the speakers that have agreed to interact in this panel, would have about 5 minutes to present a topic, and then we would move on and try to find suitable topics of discussion. Okay, I will be the moderator, and I will introduce the speakers. However, first I would like to invite Mr. Bilbao back to introduce all of the speakers before we get going.
Thank you, Goran, for this insightful presentation. And yeah, we will make sure also that this interesting meeting in October will be promoted by our Southeast Asian colleagues. Thank you, Goran. Yes, now if we don't have any questions, and you already said we move on, just to let you know that you can submit questions via the chat box. And please know that the interpretation is available for you. Once again, thank you for all that contributed. And let me start introducing Mrs. Alexandra Krakow. She's an accredited mediator at the EUIPO Mediation Center. Alexandra holds a Spanish degree, law, was a trademark attorney before joining the EUIPO Boards of Appeal. And then we also have Mr. Siaukfin Abdul Latif. He's a legal officer with the Legal Division of Intellectual Property Corporation of Malaysia, MIPOS. Mrs. Elora Carmiel Javier holds the position of attorney, an interim operations head, alternative dispute resolution service unit of the Bureau of Legal Affairs of EUIPO fields from Filipinas. And then Madame Hayak Zuradi Binti Pokto DB Haji Sidek is the Deputy Chief Executive Officer and BDAC SME accredited mediator from Brunei Arbitration Center. Mr. Jonathan Koo is the Managing Director, Vantage Lambers LLC in Singapore. He's also a specialist mediator with the Singaporean International Mediation Center. Mrs. Ruth Sabrani Sartama Saragis, an intellectual property analyst within the Directorate of Law Enforcement at DGIP, Indonesia. And then Kun Rattasina Supakarturas is a legal officer and head of Dispute Resolutions Group, Department of Intellectual Property, DIP, Thailand. And once again, Goran Marjanovic, he will be the moderator of the panel. And thank you very much for that. I hand over back to you, Goran.
Thank you very much, Gonzalo. Maybe we could hand straight over to Ms. Crocor, if you're ready. Ms. Crocor?
Thank you very much. Good morning, good afternoon from our morning, and thank you very much for inviting me to speak on this panel. So today I will briefly present to you a real-life mediation case which was successfully resolved. It was a complex trademark dispute between two pharmaceutical companies, one small family-run business in Europe and a large US corporation. We shall look at the key challenges presented by this case and the approach taken by the mediator in order to handle this particular cross-border dispute. So this is the case background. The dispute revolved around trademark rights in multiple jurisdictions. Initially, the parties tried to negotiate on their own, but they were unsuccessful. They engaged in mediation as their last attempt to settle the matter. However, there was a clear power imbalance what you might call the classic David versus Goliath situation. It already started with the fact that the US company was represented by 5 lawyers across different jurisdictions, while the European company only had 1 representative. This imbalance already created an intense emotional atmosphere, with one side using aggressive tactics, causing quite an additional stress. So what were the key challenges for the mediator? First, as I said, there was a significant difference in the legal and financial resources between the parties and in their negotiation power. Second, the case involved complex cross-border legal frameworks, making negotiations even more difficult. And lastly, the dispute was emotionally charged. The smaller company felt pressured, while the larger company took a more aggressive stance. So how does the mediation help address these challenges and lead to a resolution? Let's take a look. Next slide, please. So let's look at the mediation approach in this case. You should know that instead of a traditional in-person meeting, this mediation took place entirely online. This allowed the mediator to work with each party separately for some time before bringing them together. Concretely, preliminary discussions were key. Many issues were clarified with the parties separately per email and by holding individual meetings before the day of the actual mediation. Needless to say that the mediator played a critical role in balancing the power dynamics and in ensuring fair negotiations. So what was the outcome? Throughout the mediation, the parties identified their core interests and were able to redefine the scope of their trademark. In the end, they reached a mutually beneficial agreement. Concretely, both companies agreed to reasonable limitations of the goods and services covered by their trademarks, allowing them to coexist under a structured global trademark framework. By doing so, they avoided costly litigation and preserved their business relationships. So what are the key takeaways of this case? This case proves that mediation is an effective tool even in disputes with power imbalances. It can help parties find common ground. Having preliminary discussions with the parties separately and addressing their concerns before the direct joint negotiations may significantly improve the outcome by reducing tension and clarifying interests in advance. Finally, it demonstrates that mediation provides a cost-effective, structured approach to resolving international commercial conflicts, leading to practical win-win situations that prolonged legal battles may not provide. So, as a conclusion, I can tell you that this case shows that mediation is about finding creative solutions that work for both parties, even in highly complex disputes. Thank you very much for your time. I look forward to the discussion and to any questions you may have.
Thank you very much, Ms. Krakauer. That sounds like a very interesting and somewhat familiar mediation. But now what we're going to do here, and I already see from one of our speakers, very interesting questions coming in the chat. If it's okay with everyone, just to ensure that we have enough time for all of the speakers, we'd like to first focus on having all the speakers present, but please do keep those questions coming in, okay? We love receiving the questions because it gives us some understanding of what the participants are interested in hearing so that we can guide the discussions. But before we get there, I would like to please introduce introduce Mr. Mod Siaufik Abdul Latif. Mr. Mod, if you're ready, would you appear on the screen, please?
Yes, I'm appearing.
Hello, nice to see you. The floor is yours. Please go ahead.
Hi, hello audiences. Good evening, everyone. My name is Shaufik Latif. So I'm a legal officer at EUIPO. In my role, I typically handle the trademark and patent disputes. But today, I want to share an experience involving the copyright mediation under the Copyright Tribunal of Malaysia. So far, at least for me, mediation is not just about the legal resolution. It's about fairness, transparency, and preserving industry relationship. In Malaysia, normally corporate disputes, especially those involving the royalty payments, licensing agreements, and CMOs, has become more frequent in Malaysia. So we have new section 59C, where the Copyright Tribunal of Malaysia have a jurisdiction to hear and determine copyright dispute. So I will share briefly before moving into what I can share here on the mediation best practices. So this is a real case pending before the Copyright Tribunal, where let's take it short, where the applicant is actually a composer. They file a dispute against a CMO regarding royalty payments for his song, which achieved a significant commercial success. So despite its strong performance in digital streaming platform and public broadcasting, the applicant claimed that his royalty payment did not reflect the actual revenue generated. So one of the core issues here is the applicant alleged that royalty calculation lacked clarity, there is no data verification, and there is no fair compensation where his royalty rate should be reviewed and adjusted to the current structure. So on the other hand, the respondent, which is the CMO, defended its position by stating that the CMO has followed the industry standard licensing agreement. They also have a calculation in place. They have the rule that govern the revenue sharing among the members. I mean, the members is the music practitioners, the authors specifically. So during the mediation, there is some key challenges emerge where the applicant demanded a breakdown on how the royalties are being calculated. And also the CMO concerned that they can't breach the disclosure of the contractual confidentiality agreement because that involved one applicant. And interestingly, the applicant insists that his song's actual revenue was not fully reflected in the royalty statement. And also, the CMO clarified that royalty distribution depends on multiple licensing arrangement, which may not align with the market perception. So the applicant here, they want to request a review of that royalty formula, arguing that digital model have changes nowadays. And the CMO, they want to actually alter the formula for single artist could disrupt the collective management system. So based on this case, in Malaysia specifically, I want to highlight that so far, we have a regulation that the tribunal may ask the parties to mediate themselves before they can actually agree on their calculation of royalty in place. So my key takeaways here is very simple. I mean, CMO and corporate holders in initial place, they should ensure that the royalty calculation, distribution method are clearly communicated. If you have an uncertainties with regard to the dispute between the applicant and the CMOs, it does not solve anything. Then you need to create a trust for them to actually discuss. And this dispute in this mediation case, we are talking about the royalty discrepancies. It may be avoided if parties rely on perhaps on the independent audits, or there is a very verifiable revenue data. So mediation is actually should focus on facts, not assumptions. And thirdly, maybe it's about compromise and not just a winning. As mediator myself, it's successful mediation is one party's walk away with a workable solution. I mean, while corporate owners seek higher earning like the applicant, so by CMO manager multiple stakeholders, the key here is to actually balance the interest for long-term sustainability. So at this stage in Malaysia, the case is still pending before the tribunal and no final decision has been made. But there has been a progress so far where it reduced the complexity of the dispute by both parties, they actually clarify their financial reporting obligation. So even a full resolution was not reached in this case. So the CMO acknowledged concern about the royalty disclosure and it saved time and cost, of course. So without mediation, this could be escalated into a prolonged legal battle. Even they might have a judicial review to the High Court, perhaps. So in conclusion, since I have 5 minutes only, so I mean, this case highlight the growing importance of our newly amended Act in Section 59C, where Malaysia, I think in Southeast Asia, Malaysia is the only country that the tribunal can ask the parties to mediate and they can actually hear the dispute regarding the royalty payments between the CMOs and its members. So I think we just have to wait for the tribunal financial decision. But one thing is very clear, that mediation should be a fundamental part from the trademark patterns and design in place, but also the corporate tribunal as well. Thank you very much.
Thank you very much, Mr. Latif. I think it's very good to hear a copyright example. So thank you for bringing that. Unfortunately, at the EUIPO, we don't get too much interactions, especially with the CMOs, because we do not deal in that domain. But indeed, as you point out, let's say a lawsuit between a individual composer and a CMO inherently represents a big power imbalance, sort of what Ms. Crocor mentioned in her earlier example. So we're already seeing a trend here that mediation can be very effective in situations where there's a power imbalance. I really appreciate your presentation. I will now move on to Attorney Javier from the Philippine office. My colleague, if you're ready, please, the floor is yours. I will stop sharing because I understand you wanted to share a PowerPoint, correct?
Yes. So good afternoon and good morning to everyone. I will be sharing my screen. Okay. So there. Just to give you a brief background for the intellectual property of the Philippines. So in the EUIPO field, we actually have 3 options for our mediation service. So we actually have the mandatory mediation, which is the adjudication-based mediation. And then we also have a partnership with the EUIPO, wherein we also refer disputes to them if the parties do feel that the EUIPO would have better understanding because they're part of different jurisdictions other than being a domestic dispute. But now more of our advocacy here in the Philippines is that we have a planned early dispute resolution, which we call mediation outside litigation. So this was actually introduced as one of the remedies in the Philippines pre-pandemic. So in the pre-pandemic, we were trying as much to advocate for this. However, not a lot of parties would like to avail of this option. So we even offered waived fees for this, so that more parties would be able to submit or defer their disputes to mediation outside litigation, because we want them to be able to have an option for them to mediate between each other before filing a case with the EUIPO field. So what does this mean? So it means that the 2 parties already recognize that they do have an IP dispute between them. So what we usually see here in the Philippines are usually trademark disputes. And as well, our first successful outcome is actually a trademark dispute as well. So we actually just had our first successful outcome last September last year. And this was between a big food and beverage conglomerate here in the Philippines. And the one that they have an IP dispute with is actually one of their business partners. So similar with the first two mediation experiences, that there is a power imbalance between the both of them. So the this actually involves a very distinctive trademark wherein one of the subsidiaries of the conglomerate is using for an ice cream brand. And um, the the respondent in this case is actually one of their business partner who is using the trademark as their brand name or their trade name. So that was the contention in this case. This mediation outside litigation case is actually it took them around more than a year, or specifically 18 months, for them to be able to reach a successful settlement agreement. So because of this, um, it's actually a consolidated case of half of the cases that were actually filed cases, so meaning they were under the mandatory mediation in the Philippines. And the other six, because it arose from those six earlier cases, they opted to consolidate the whole thing into a mediation outside litigation. So um, the mediator actually took the time to really get into what are the things that, what are the areas that the parties can be able to compromise with. So as you can see, this was a very public signing of the compromise agreement because we wanted to um, advocate it to our clients, to the public, that this is a viable remedy for them, that they don't have to go through adjudication, that they are able already to just settle between the both of them. They are able to select their mediator, and then the mediator will do their best if there is really something to be compromised with, there is something that they can settle with, and they don't have to go through adjudication. So, because of this case, we already actually receive a lot of referrals for mediation outside litigation, not just for trademark. We actually already receive inquiries regarding copyright issues. So we can see that the public already can recognize that they already have they can empower themselves in choosing what kind of dispute resolution they can use, especially that the IPO field is giving them a lot of avenues for them to have a dispute resolution for their IP disputes. So we hope that our mediation outside litigation um, remedy would be able to even um, resolve patent cases, because usually that takes quite some time here in the Philippines for them to be able to get a resolution. And sometimes the patent already expires even before the resolution of the case. So we hope that this remedy would be able to give them an avenue to be able to resolve their disputes quickly and even outside of litigation or outside of adjudication. So that is for the Philippines, and I hope you are able to get a thing or two, a key takeaway from our best practice. So thank you so much.
Thank you very much, Attorney Javier. Always a pleasure, and congratulations. I do recall that you've presented on the mediation outside of litigation in the past. So to have San Miguel Foods sign a settlement without even launching basically legal proceedings, we find this a tremendous accomplishment for you and your office, and in particular, I think everyone benefits, the office itself, and as well both of the parties in that regard. So thanks so much for sharing this. And I will now introduce our next speaker, who has already asked a very interesting question in the chat. So thank you for the question. Perhaps we can talk about it. Madam Haja Suraida from Brunei Darussalam Arbitration Center. If you're ready, could you please appear and say hello to our audience?
Yes, thank you. Can you hear me?
Hello. Yes, perfectly.
All right, okay,
Welcome.
thank you.
Good evening.
Thank you. Thank you to the moderator. I am Zuraida and I represent the Brunei Darussalam Arbitration Center. The center is the sole center that provides ADR services in Brunei, including mediation. We are a new institution, having been fully operational since 2022. So in terms of the challenges that we face in ADR and specifically in IP dispute, there's about 4 challenges that I want to inform this particular group. Firstly, we have an absence of legislation on mediation. We do not have any mediation legislation at the moment, though there is the legislation is being worked at. So because of the lack of legislation, we feel that it may lead to challenges in the enforcement of mediation settlement agreement, and it may pose ambiguity in mediation procedures and standard. Our second challenge is actually our biggest challenge is limited awareness. And this is not just in IP dispute, but generally in most dispute cases, while specifically legal practitioners and certain key stakeholders are aware of mediation and its benefits, we still see there's a lack of the consumers wanting to use mediation as a dispute resolution. Even more so in IP dispute. So currently, one of our institution is working with key stakeholders, specifically in the construction industry, to give awareness on mediation services to their particular industry. And also, we find that even to put mediation clauses into certain contracts, we still lack. We're still working on that to ensure that most of the industry in Brunei adopt mediation clauses within their contract. The other challenges is the need for IP specialized mediators. There is, for most businesses, there is a lack of awareness in terms of that their IP dispute can be brought to mediation. And we do not have IP mediators for which the stakeholders can seek advice. So that's one area. In Brunei Darussalam Arbitration Center, we have about 48 mediators, but these mediators are expert in mostly construction, in general contract dispute, in family matters. But we do not have any specifically on IP dispute. And also the other challenges is we recognize that perhaps there's a need for a dedicated IP mediation framework. While BDAC is capable of conducting mediation for any kinds of dispute, a structured framework specifically for IP mediation, which is crucial to ensure consistency, clarity, and efficiency in resolving IP-related dispute, is still lacking. So another area is perhaps a collaboration between with Brunei Darussalam Arbitration Center with our local IPO office, which is the Brunei Intellectual Property Office. We haven't had any collaboration with them. We haven't had any discussion as to where we want to bring IP dispute in Brunei. So that's one area that we would like to engage with. When we did our research, there are actually 6 IP cases that were brought in Brunei, 2 of which were brought before the criminal court, 3 before the civil court, and only 1 case was settled out of court. But none of these cases were actually brought for mediation. So that's the scenario in Brunei with regards to IP dispute cases. Thank you.
Well, thank you very much, Ms. Zuraida, for this presentation on the situation in Brunei. Well, definitely we can kind of understand what you're going through, particularly on the awareness side.
Yes.
That, as you're saying, a lot of users or a lot of litigants aren't aware neither of the option of mediation, and even if they are, they might not be sure exactly about what it means or how it works. So there's a lot of work to do there. And this is something we can also talk about going on through our panel, how to best promote mediation services. But good that you have plenty of space for improvement, such as having a contact with your IP office in Brunei, and
Yes.
perhaps even developing something jointly could be potentially of interest. So, and I also thank you for your questions, because you were talking about how to decide which IP disputes are suitable for mediation. We do have a presentation on that, which I will share. It's on our Mediation Center webpage. There's even a webinar on it. And so I'm going to post that into the chat as soon as hopefully the conference technician can let me know which option to use to make to send a message to everyone that's participating in this webinar. I will share the link. In the meantime, I would like to introduce our colleague from Thailand, our colleague from Singapore, from the Vantage Chambers. I was skipping ahead. Sorry about that, Nisa. Mr. Jonathan Chu, please, if you would.
Thank you, Goran, and I hope everyone can hear me. I bring you greetings from Singapore, where it's we're in the middle of the monsoon season right now, so it's quite hot and wet over here. But it's a good afternoon from me, and a good morning to everyone dialing from Europe and elsewhere. I want to thank, of course, the organizers for inviting me here today. Today, I'm an independent arbitrator and a mediator, and I'm representing IPOS in Singapore in terms of giving some comments today. Let me begin first by just sharing a very quick comment on the mediation scene in Singapore, and then I will very quickly just offer 2 case examples very quickly, just to touch on that, so that we have an idea of the sorts of matters that we've been handling in Singapore. The first observation or comment I have is this. The mediation scene in Singapore is still quite nascent. We've started to see over the last few years a big uptick in the interest in terms of parties wanting to refer their matters to mediation. Previously, many parties would shy away from doing that, but now we've seen a lot of parties are actively exploring mediation at various stages. And I think it's got to do with the fact that a lot of the different stakeholders are being engaged as to the benefits of mediation. Now, there are a number of schemes in place available in Singapore to encourage mediation, but really it's done by way of contributing some funding in exchange for parties agreeing for some parts of their case to be published. so that the public, when they get a chance to read about those cases, it helps to demystify mediation. It helps parties to be able to see that there is a way forward by attempting mediation. Some of you might have already heard of the EUIPO ASEAN Mediation Program, or EMP+. That's been available for a while. And IPOS, Intellectual Property Office of Singapore, also has its own scheme called the Revised Enhanced Mediation Promotion Scheme, or REMPS. And really, if you want to find out more about these schemes, just visit the website, and you will also be able to see some published examples of the types of cases that have been successfully resolved through mediation. Now, I'm personally responsible for some of these cases that have been resolved. I think it's in that capacity that IPOS has invited me to speak on their behalf today. So I'm very quickly going to share two examples. In one case, it involved a Malaysian party, so part of an ASEAN entity, a Malaysian party. They were an F&B outlet with several branches, and they had a dispute. They had a trademark opposition. They encountered a trademark opposition when they were trying to file the trademark in Singapore for their brand. The party opposing the trademark registration was a very large international supplier of raw materials, ingredients, supplies of that nature. And their objection was on the basis that the name of the F&B applicant, the trademark applicant, the name was similar to the brands of one of their products. And this was referred to mediation. And I sat as the mediator in that matter. From start to finish, it took less than a month from the time that I was appointed as the mediator to the time that we had the hearing. And on the day of the hearing, when parties managed to settle, they drafted the settlement agreement on the spot, and it resolved. And this was a very significant matter for a number of reasons. One was because it was international parties, but the mediation hearing was conducted on a hybrid format. So the Malaysian party took part in the mediation online. The trademark, the owners of the trademark were represented by Singapore Counsel, who appeared before me in person, and their client appeared before me online as well. So it was a hybrid mediation, which meant that it was a bit tricky in terms of how, as a mediator, you deal with such matters. But I found that with the benefit of me having had pre-hearing discussions with each of the parties, I managed to understand the cases quite well. I understood which points were particularly troubling for them. I understood what their real interests were in trying to get this resolved. And I think that really helped it when we attended the hearing, even though it was in hybrid format. It was quite easy for us then to be able to get to the gist of the issues to be resolved. Now, this being a trademark opposition matter, there was also a very delicate issue of how to depict the trademark. And you can understand how, in terms of certain drawings, it's a little bit difficult to communicate that when you're all in different places. But credit to the parties, we were able to resolve those issues fairly quickly on the day of the hearing. In fact, from the time we started the hearing to the time we managed to get the resolution, it took no more than a couple of hours. And then the rest of the time was spent drafting up the settlement agreement. So that's one case. Another matter that I was involved in as a mediator, it was a copyright infringement and trademark infringement claim. And that made its way to the Singapore courts. And at one of the preliminary hearings, the parties were invited to consider mediation. And to their credit, they decided to take the matter out of the courts and to attend mediation. The dispute was between two owners of traditional Chinese medicine halls. They were TCM practitioners, and they were competitors. And the claim by one party was that the other party had infringed some of their online copyright, and also one of the products were being sold without their permission. So that was quite contentious between the parties. When it first started out, they were very, very far apart. One party, even though the mediation was officially conducted in English, one party was clearly more comfortable speaking Mandarin. And so this was made possible. I mean, they invited me to mediate the matter. And even though I conducted, I would say, the majority of the mediation in English, there were some parts of the mediation where it became a little bit, I think it was better for me to conduct certain parts of the mediation in Mandarin. And that, I think, helped to break down some of the barriers between the parties who later on themselves, when they had their private discussions, they also spoke in Mandarin. And eventually, I think we managed to resolve the matter after much anguish. It started at 9 a.m. in the morning, and we finished at 2 a.m. The next morning. But it resolved, and the settlement agreement was signed. I think this is an example where you can show that how mediation can be flexible enough to accommodate some of the nuances, some of the cultural aspects even between the parties. So those are my very broad comments. Hopefully you have a better idea of how some of these IP matters go to mediation. And if you have any questions at any stage, please just reach out to me. I'll be happy to answer.
Thank you very much, Mr. Chu. Really excellent examples there, and from two quite different angles on top of it. Congratulations on such a speedy opposition mediation. That's amazing. We want to learn from you. In fact, I'm thinking about, I've never been in the hybrid setting myself. I think it would make me nervous. So if it ever comes up, I might get in touch with you to see how to handle it, because that's very interesting. But also on the copyright side and the cultural aspects and changing languages, I think this is something that we do at the EUIPO quite a lot. So we imagine that the same type of cultural issues would happen in the ASEAN context. And thank you for that example. Now, also wanted to mention briefly that we've had more or less the same type of experience at the EUIPO concerning interest in mediation, which was your introductory point. We've been on the phone quite a lot over the past 4 or 5 years with the litigants. And let's say initially we noticed people didn't really understand what we were talking about. And now we're getting to the point where we barely have to explain it. And you see that goes hand in hand with the numbers going up. So we're maybe at a similar stage as the experience that you're having in Singapore. And perhaps this is something that we can continue to talk about in the panel as well, on how mediation can be promoted, because that's always been an interesting topic. In the meantime, I also wanted to let Madam Zuraida know that I've pasted in the link to a kind of promotional material called 10 Reasons to Mediate. That goes into some of the factors that could maybe be used to convince parties to mediate, but there's more. So that's another topic I believe that we can continue talking about. And now I think to not waste too much time transitioning, it's our next colleague is from DGIP in Indonesia, and Ms. Ruth Svarni Sartaram Sargi has a PowerPoint presentation as well, from what I recall. So Ms. Ruth, when you're ready, please join us. Thank you.
Yes, I'm ready. Mrs. Aksan, please help me. Yeah. Good afternoon and good morning, everyone. Today is a great opportunity to join this webinar and share our experiences in Indonesia regarding best practices of IP mediation. However, before sharing, allow me to provide a brief introduction of mediation at the Directorate General of Intellectual Property, or DGIP. At DGIP, we have approximately 82 accredited mediators assigned to several directorates with the following details as you can see on your screen. Next. The implementation of mediation itself is divided into two mechanisms as follows. The first one is mediation upon request or application, and the second one is mediation upon complaint report. According to the law in Indonesia, IP infringement that require mandatory mediation before filing a criminal lawsuit are copyright, related rights, and patents. Next. For your information, here is the mediation case at DGIP from 2021 until 2024. Total case is around 101 cases. Next. Here are some cases that have been successfully mediated. The first case is trademark. The trademark dispute over a watch brand called Elfano between two parties who established a joint business selling watches, claim over the brand ownership. The mediation was successful, with one party transferring the ownership rights to the original founder, paying compensation and stop using the brand. Next. The second case is about the copyright between one of the biggest recording company in Indonesia, called Aquarius Pustaka Music, versus multinational consumer goods corporation called PNG. PNG used 11 songs under Pet Aquarius as the theme songs for their advertisement without any consent from Aquarius. The mediation was successful. PNG were willing to pay compensation and stop using the 8 songs, but PNG was allowed to use another 3 famous songs to be the theme songs for their advertisement until the end of 2023. Next. Here is the summary of the best practices we have implemented. There are 3 phases of the mediation. The first one is pre-mediation. The second one is mediation. The third one is mediation implementation. Pre-mediation is the key to the successful mediation. In this phase, the mediator established a psychological approach and built a psychological connection with the dispute parties. This helps the mediator gain a deeper understanding of the substance and the expectation of each party, which will be highly useful during the mediation process. Pre-mediation facilitates the smooth execution of mediation. The second one, in mediation, the mediator facilitates discussion to find common ground and mutually beneficial solution. If necessary, the mediator may hold separate meetings or caucus to explore each party position in more depth. And the third one, the mediator ensures that the discussion remains focused on problem solving. The pace of mediation implementation. If both parties reach an agreement, the mediator assists in drafting a written settlement. The agreement must be clear, concrete, and feasible for implementation. The parties review and sign the agreement, and the last, both parties implement the agreement. Next. Here is the mediation process at DGIP. We can describe as below. You can see on your screen. And the last one will be the reasons for choosing mediation. The first one is lower cost, and then saving time. Deliberation is prioritized and guaranteed confidentially. So that concludes my presentation. I hope this presentation will be an inspiration and evolve into deep discussion. Thank you.
Thank you very much, Ms. Ruth. Again, great to see different situations with different IP rights. And on that point, actually, you reminded me about something I wanted to mention, which I think already started with Ms. Javier's example of mediation outside of litigation with San Miguel Foods, basically publicizing the fact that they reached a settlement. The same with Mr. Chu was saying that one of the requirements for financial assistance in mediation is that the parties agree to, let's say, promote somehow their specific case. And I see as well in your presentation that you're using the actual names of the companies and all of this. Now, we've also found really interesting that one of the selling points of mediation, right, is the confidentiality. But then you find many times that the parties have such a good experience and maybe even want to let their customers or supply chain partners know that they've reached a settlement. So they in fact want to publicize that they've gone through this. So we've had some situations like that at the EUIPO as well, where we've seen them publishing articles, but that's because they agreed jointly that they're allowed to share things. And I think that's something, like you said, is it motivating? I think that's a motivating thing when you see parties happy about their experience. But also I think something very motivating from your side should be the fact how involved the mediator is in preparing the settlement agreement. I think this is a really tremendous value added for the parties, particularly if you have less sophisticated parties involved in the mediation. So thank you very much for this presentation. And we will now move on with the last but not least, our Thai colleague, Ms. Ratnisa. We're happy to see you again and look forward to hearing what you're going to say.
Happy to see all of you again. Again, please, my name is Ratanisa Suphacharulat. I'm a head of dispute resolution group in Thailand. If I would like to briefly, just only a bit about the mediation service in Thailand. Actually, we serve this service since 2002, and nowadays we have the application around almost 800 cases in Thailand, and mostly it's a copyright case. And today we talk about just only sharing about experience, right? And nowadays in Thailand, as all of you already know, mediation service in Thailand, we have no charge about this service. It means it have a chance to the entrepreneur or everyone to use this process. And in Thailand, mediators consist of the expertise in DAP officials, and is why the number of the cases in Thailand is like more every year. And the case that I would like to focus today is a contract for the hiring of work. I mean, when the hiring a contractor to do a job, that time an IP infringement is happened. For example, the contractor download a copyright program front without permission and use it, like a misuse about the term and condition. And that time to design a restaurant sign such as that. When the font owner fight about the infringement, they demand a compensation from the contactee, because the contractee was the one to display the sign in their business, or to use that one, such as the restaurant name ABC. Even though in Thai law may see this act like the secondary infringement, but there are still responsibility for this infringement. And in mediation state like this, in Thailand, normally the contractor agree to compensate the copyright owner on behalf of the contractor. It means in the experience from mediation like this, we work like this to show that we need to educate the business owner as a follow. Number one, should to check for any IP infringement in the work being the hired, such as the delegate of Brunei, about to awareness the IP knowledge to the entrepreneur too. In DIP, we have a free consultation center where they can consult if they would like to use some of the name of the restaurant. We should to check before to our DIP about this name have the trademark register or not. If they check before they do the business, it cannot have the dispute in the future. Or you can check to review the copyright terms and conditions, such as you can ask the official, DIP official to like review again about the term of the condition in the copyrights, about that is for free or not, or this picture is can use for commercial. Because nowadays in Thailand, as I ever said to when I shared experience in Thailand, the people in Thailand sometimes they don't know much about the image that we search in the internet. Is not for free. All of that is sometimes have a term and condition to check again. This is the issue that we found when we do the mediation process. And the second thing that we have to educate in when the mediation process come is have a clear contact to stating that the contractor currently the works is not copy or infringement or anyone's IP. If the infringement is found later, the contractor shall take the full responsibility. It's why nowadays we just not do just only the mediation in this process, but we have to like acknowledge to the people that use this process too. Yes, I would like to share just only this, Mr. Goreng.
Thank you very much, Mr. Nisa. It's great to hear that your numbers of mediations continue increasing in Thailand. And I do recall from Manila, and it was, I think, similar with Indonesia and Malaysia, that because of the competences of the office in the copyright field, so music and digital social media usage, that the highest amount of cases for mediation seems to come up in these areas, which is interesting because it's almost as if your offices are creating very specialized mediation services for this online and copyright sector. So it's really, really good to hear those examples. Thank you for sharing. We've now had all of the speakers introduce themselves and present their topics. Thank you all for that. So we have about half an hour left for a mixture of discussion and for question and answer. Now, we did receive one question, which perhaps if you're all okay with it, I would use as a starter. We received a question in the Q&A box, and it reads as follows. Time to reach a settlement is key in mediation success. For instance, in Philippines, what are the average times taken to settle cases through the various mediation channels? So I think this is something that's specifically addressed for Ms. Javier, but I think it's something we can also all chime in on. So I would like Ms. Javier, if possible, to start off the discussion on this topic, and then the other colleagues to prepare themselves to contribute, please. Ms. Javier.
Okay, so thank you for that question. So as seen here, what are the average times taken to settle cases through the various mediation channels? So as you saw in my presentation, we do have three channels. So 90% of the disputes usually come from the mandatory mediation. So what that means is that these are cases that are already filed with the IPO. And usually we have this early termination option wherein parties that undergo mediation, they are briefed in the preliminary conference that they will have 30 days for them to have a mediation proceeding. And after the 30 days, If they opt to continue with the mediation, they may do so, but they can also avail of the early termination option, meaning they would like to refer the dispute back to adjudication. So for the other two, so which is the WIPO option as well as the mediation outside litigation, because we do refer this to other parties, so meaning with a WIPO, it depends with the parties how long they want to do the mediation proceedings. With one dispute that we've had before with a WIPO, I think it took them around a month or two for them to be able to agree that they would like to refer it back to adjudication. For the mediation outside litigation, because we only have one successful outcome so far, we do not have an average, but rather this is just the timeline that the parties opted to negotiate among themselves. So this was 18 months. So once the other cases or the other disputes that have been referred to mediation outside litigation have already concluded, I think that is where we can have a ballpark figure of what are the average time for them to be able to settle or refer the dispute back to adjudication. But again, for mandatory mediation, they have an early termination option after 30 days. For the WIPO, it's about a month. For the mediation outside litigation, it's about a year or so. So I hope that answers your question.
Thank you. It sounds very clear. And a follow-up question maybe from me would be, are there any maximum suspension or stay periods for the average IP proceeding that would basically force the parties to commit to mediating more efficiently?
So right now, we do not have a specific stay. We just give them like the early termination option, and then that's where they can opt to if they would like to proceed. But if we do have proceedings that already went above 30 days, and we still want them, they still told us that they want to negotiate among themselves. So we just let them, because if that is what will make them settle, then who are we to just tell them to already settle or already stop the proceedings? So as much as possible, we give the parties the leeway to be able to tell among themselves that this is the resolution that they want to do. So as much as possible, we do not give them a deadline that you should be able to settle within 6 months. As long as they're willing to do their negotiations, as well as the proceedings themselves, we just let them be. That is why I guess the mediation outside litigation took so long, because we wanted as much as possible for them to be able to settle. And if they already told us that they opt to not settle, then we also give them that option as well.
Thank you. Well, we've noticed that the EUIPO, I think it's part of the motivation why we're undergoing a revision of the rules of mediation. And part of that was as Ms. Karin mentioned initially, was quite inspired by the meetings in Manila, where we also remember from the Singapore office, the 3, 6, 9 month options that parties have to kind of choose a term for the duration of their mediation. We had found that ours kind of go, under the current rules, could go either way. That they could either take long because the parties are drawing out the process, or they could be very quick because the parties are motivated in resolving the issue. So maybe Alex, Ms. Crocor, would you mind giving an example of 2 recent situations?
Yes, because as you say, I mean, until now, we did not have any deadlines in the EUIPO. So it was very much up to the parties how they wish to negotiate, mediate. And we can see from different parties how the interests are. We have found that some might want to even prolong the situation because it is they have some tactics or that we don't know about. And of course, this is something we want to avoid. For example, actually, Goran and myself, we mediated a case that took more than 1 year, and they still haven't finished the drafting and concluding the settlement agreement. But as Attorney Javier correctly says, who are we then to stop that we avoid that we don't help the parties to efficiently find a settlement at the end? So we're not pressuring too much, although what we have at EUIPO, we have pending appeals right now. So these appeals cannot be suspended forever. So this is something that we're trying to convey to the parties. Since mediation comes out of our office, we need to remind them that obviously they have appeals pending that cannot be forever. But we've seen in other mediations, there was actually one recent one I handled, that where the attorneys alone, they already had found a solution with the restriction of the goods and services, and that went within 4 weeks, which I must say is really a quick resolution to the matter, which involved 2 appeals. So that was very successful. Mediation, we have to remember, is a flexible process. So it is ultimately up to the parties, with us trying to establish some kind of rules, which, however, also remain flexible.
Thank you, Ms. Krokor. Yeah, it's important even psychologically for the mediator and for the parties to establish a rhythm and keep the momentum going and not let things cool down too much, which I think is a bit what this question that came through the box is trying to get at. Now, I would like to, if any of the other panelists would raise their hands if they have any comments to make with respect to duration and average times. If not, we will continue. We will continue with another question from the box. Now, this comes from university setting. I'm working in the IP management office in the university. How does IP mediation differ in university setting compared to corporate disputes? Now, maybe if any of the panelists is comfortable or understands fully, I'm wondering whether this is a copyright situation perhaps, and it's about academic or learning a sort of exemption for copyright usage. But do any of the panelists want to chime in on this question? No? Okay. So what I could tell from the EUIPO context is that if a university was involved in a mediation by the office, it wouldn't be treated any differently per se than any other type of company or corporation. Now, it would be with us because there would have to be at least a trademark or a design hook to give us the possibility to mediate. Even though to me, potentially, it sounds like a copyright case here. We have in the past had cases where there's multiple different types of IP rights, because please recall that one of the great benefits of mediation is the fact that you can resolve many different disputes all in one mediation. So what we would do is, if we had a university that had a trademark or a design issue and there was an underlying copyright situation behind it, we would group all of those issues into one mediation and try to address it. But at the same time, maybe also, Ms. Krokor, just a quick question for you. Being that trademarks and designs are a hook to trigger us, our mediations, have you ever had copyright elements in any of your past mediations?
I haven't had any copyright elements. What I have had is designs, which of course is not the same. but this is a new field that we're going to encounter briefly in the office as we're opening up the Mediation Center to the design section. And these are very interesting cases which are a bit different from the trademark cases because they also involve a creativity and a whole process that was behind the creation of the design that will be very important to the companies, and where once again we will be faced with situations such as the power imbalances and maybe also from inside the same company more conflicts that will arise in that sense. So definitely interesting times ahead for us in that sense.
Thank you very much. Now, with that, it's true that we'll have hopefully more experiences to share with the ASEAN colleagues that are regularly already handling copyright disputes, which sound very interesting to me. But in the meantime, as we're already talking about different types of cases, one of the initial questions that came from Madam Suraida, but I think some other participants are maybe thinking the same, is how do you know whether a IP case is suitable for mediation? We do have our webpage tackling 10 reasons why mediation is suitable in IP cases. They're quite general. So in a way, it was a promotional material, and we have a webinar that you can see online on that. I think just about any IP case, therefore, will fall somewhere in there. But I can also say that we've gotten a bit more technical about it from a data analysis perspective. So what we've been doing is we've been going into our systems and extracting information on different characteristics of proceedings. So one of the things that we're looking into doing now is targeting cases, in trademark cases, of course, where basically there's a suspended or a stayed cancellation proceeding. Why is it stayed? It's stayed because the earlier right is under attack, meaning there's been a counterattack, meaning both parties potentially stand something to lose, potentially. Both parties also definitely stand to expend a lot of effort and perhaps money on the situation. So perhaps this would be a motivation to choose mediation. We're going to start this pilot soon, and we'll be able to talk about how it works. But I'd like to hear also from the other colleagues what kind of cases they think are particularly suitable for mediation in the IP context. Please. Any takers? Okay, Mr. Chu, please.
I think that as long as a case involves the determination of rights and obligations between those two parties, or sometimes it's more than two parties, between the parties to the mediation, then I think that's the sort of dispute that really you can resolve through mediation. And why not? There's so many advantages to doing that rather than through going through the formal processes. Another thought that came to mind is, and maybe this harks back to an earlier question, I think that for a lot of parties, how long you take to mediate and settle the dispute is a very important question, because if it's going to be very long drawn, then immediately you lose one of the big advantages of mediation, right? Why do parties even attempt mediation if, let's say, it's going to take as long or even longer than the formal process, be it litigation or arbitration, let's say. So I think we need to strike a balance. Clearly, we want to give parties every opportunity to try to mediate and resolve their disputes amicably. But we also don't want to fall into the trap where parties start to realize and they think, hey, this is not going anywhere, it's taking too long. Or worse still, I think it's a comment that was also made, one party thinks that they can weaponize mediation by trying to drag things out unnecessarily at the expense of the other party and expense of of justice or expense of the process itself. So I think it's a very, very delicate situation that needs to be considered. Wearing my other hat as an arbitrator, some of you might also be aware that these days there are processes in place where parties, let's say it's a dispute that needs to be ultimately resolved by arbitration, it's very possible for parties to use what's called arbitration, mediation, arbitration, ARB-MED-ARB. And so they commence arbitration proceedings. So the timeline has already started for the arbitration. Immediately, the matter is then referred to mediation, and then there's a time process in place for that mediation to take place. If it settles, then parties make use of that settlement agreement, and they have it recorded in the arbitration as an arbitration award, which is then enforceable around the world by virtue of the New York Convention of 1958. If it doesn't settle at the mediation stage, then no harm done, because the arbitration process has already started. And so what then happens is that the process then gets transferred back into arbitration. So that's another way parties can think about, trying to make use of the available processes that are out there to get their disputes resolved. I really believe IP disputes, or for that matter, any other type of disputes, there's no one-size-fits-all solution. Every case needs to be considered on its own merits and its own factual pattern and also own circumstances. And what we really should be doing is exploring what are the best options for getting things mediated, settled, resolved for the parties.
Yes, thank you very much. Absolutely. So many good points there that indeed another way to answer the suitability question is, well, if both parties want to mediate, then it's a suitable case. So I think that's the most important one, and we sort of overlook that. It's a voluntary process, and when they feel that they want to help themselves or want to be helped in a way, that's great. That's the first step. But you're right as well that each case is its own story, and each parties are unique individuals. It's back to the human aspect of it. So often when you take a mediation and you look at the summary of it, you don't really yet know what you're getting yourself into until you've interacted with the parties and started to see what it's all about. So thank you very much for sharing those points. And also, Ms. Crocker, would you like to chime in, please? Then Ratanisa afterwards.
Thank
please.
you. Yes, I wanted to comment on Mr. Chu saying that obviously we sort of can see which way is the best to go for the parties. And I wanted to ask also my colleagues in the panel, do you see it interesting, for us mediators to be experts in the field, or do you think it's not necessary? Because I have the impression from my experience at the EUIPO that it is very useful to have a legal background and especially a background in IP, because obviously it's up to the parties to take a decision how they want to resolve the case, and we are not supposed to give them any kind of legal advice, but we know what we're talking about, and we might lead the parties in a way that can expedite this resolution. I don't know what my colleagues on the panel would like to say something on that.
Perhaps, yeah, Mr. Ratnisa, in fact, what I understood is you have IP specialized mediators in the Thai office. So perhaps you want to comment on that and whatever other comment you were going to make, please.
Yes, from my experience in Thailand, the higher application is the infringement in copyright infringement, right? And we found about it easily to entrepreneur or infringer to apply in this process, because if they sue to the court, they have to like prove burden of proof about their confidence about this is the owner have a right or not. But if they come to DIP office, we will principle to check just only a bit about we confirm a bit about the owner have the copyrights or not. such as that. It means it's easily to infringer to come with us to use this service. And after that, it's trademark. And its trademark is like normally to when they settlement agreement is easily to change the name of the trademark. It means the IP that easily to use the mediation process is not just only the two party, but it's issue insight about it's easy to settle agreement or not. Some of the case they already settlement agreement together outside the DIP, and when they would like to go to the DIP office, just would us to be a witness about the agreement to confirm this is copyright owner or not. It means the mediation service like this is take time just only one day. Is shortly to settlement agreement together because the two party already negotiate by themselves outside and just would like DAP to be a agreement or check about the detail agreement. And the longest of the mediation service in Thailand is the one of the party would like to delay the period of time. Maybe they would like to decide a bit about which one to sue to the court or to the continue the mediation process is suitable for them. About the DIP, we would not to delay until 1 year per case. We would like to limit the time is not over a year. Yes, and normally we can do that. Yes, it's all I would like to share.
Thank you very much, Ms. Ratnisa. I think again, it's really great to see that added value services that the Thai office puts in facilitating the actual settlement and the conclusion of any kind of alternative dispute resolution before the office. And I guess that would also indicate that some higher degree of expertise, such as IP related, is really needed for the mediators in the Thai office, and also for the efforts in trying to limit, let's say, the duration so that there's no abuse. Yes, we've seen that we are going to tackle that quite seriously, because that's a matter that can absolutely frustrate the counterparty and the office, and it's not a good faith approach. So thank you for talking about that. In fact, one of the questions about IP expertise that was also followed up in the chat was, I'm gonna read it out for you. It's related on that. Perhaps it's going to be the last question because we are running out of time. So basically, one of the participants says, does the panel think that giving the mediator more power would help in achieving settlement faster? Very interesting question. I'm gonna kick it off quickly from the EUIPO perspective. We have another service at appeal level called conciliation. A conciliation can be proposed by the rapporteur of the appeal, the person who will be inevitably responsible for taking the decision, and it can be done in a more proactive manner than the mediation itself. Basically, it's already proposing potential solutions, options, or one concrete one, and then if the parties agree to consider it, entering the negotiations effectively at a more advanced stage, meaning that I can tell you from a timeline perspective, they are generally faster than mediation. So what do you think? Does it make sense for the parties, when they see a mediator is competent in their type of dispute, to propose potential solutions, or do you think a mediator should more function in their classic role of facilitating discussions that would get the parties to reach their own solution? Please, if anyone has opinions. Mr. Chu, please.
I'll take a stab at this. I think that there are different roles that mediators can play. I think that of course, one way of thinking about the mediator's role is the facilitative style of mediation. A lot of us are used to that. But there's another style of mediation, which is the evaluative style. Some parties like that, and I think that if both parties, or however many parties there are to the mediation, if they want a mediator with the evaluative approach, evaluative style, then they should make that known. And I think then there will be no misunderstanding once that mediator exercises that particular style. Personally, I think that there's a lot of power itself for the mediation process. There's a lot of power itself in the parties having the say. So I'm a big believer in giving the parties, empowering the parties to be the ones to shape the outcome of the mediation, not so much the role of the mediator. That's not to say that the role of the mediator is unimportant, but really, I think the skill in the mediator, from my perspective, is in empowering the parties to arrive at the settlement that best works for the parties. If the mediator can amplify that, that's great, rather than a situation where effectively the mediator plays the role of an adjudicator to pushes a certain agenda or certain decision. But of course, it is up to the parties.
Thank you very much. And Ms. Javier?
So actually, just to come from what Mr. Cheese just said. So again, the mediator does have a lot of roles to have, especially here in the Philippines, that the parties are sometimes they want to have assistance from the mediators. Like here in the EUIPO field, a lot of our mediators are litigators as well. So they have the requisite knowledge needed by the parties, especially if these are parties that are first timers in mediation. So they need some hand holding. And for them, usually they interchange conciliation with mediation, especially here in the Philippines, because they think that mediations, for mediators, they want them to have already a ready solution for them. So they want to make the mediation proceedings more clear-cut, and they would like to say, ask the mediator, like, who has a better right in the situation, which is not supposedly what the mediation is all about. So maybe with here in the Philippines, that's why we are more advocating on what is the delineation between mediation and conciliation and even negotiation. So that's why when we do accredit our mediators, we want them to have the substantial and procedural knowledge for them, especially in mediation and in intellectual property, for them to be able to make the proceeding much more free-flowing for the parties, and maybe let them understand that mediation is not about really the settlement, but rather them understanding their issues, their interests, as well as what is the IP dispute all about. So I guess that's my take coming from the Philippines perspective. Thank you.
Thank you again, Ms. Javier. Yes, really good points that in many situations, the mediator could be almost more like an educator, trainer, and a coach rather than just a mediator, though then, of course, you have to be careful because in some parties where that are very sophisticated and very legal, it's also important to kind of give them the space and not seem like you're trying to teach them something. They might take it the wrong way, but totally right. And I just want to say that I really, really enjoyed this panel. It's been one of the best ones. So thank you so much for your input. For us in Alicante, it's still early. I could keep this going for another 2 hours and have a great time. But I understand for you in Asia, it's getting late and you probably need dinner and to see your families and all of that. So Alex, if you could give a final remark quickly, I invite you to do so, and then you can pass the floor to Gonzalo, please. But thank you so much to all of our colleagues for participating.
Thank you very much, Goran. I just wanted to remark, and maybe it's a nice closing statement as well, that we should not forget what the objective what our ultimate purpose is in mediation is that parties find, hopefully through us, with our help, an enduring solution. And this is very important if we're discussing the different types of mediation, if we want to be mere facilitators or pass on messages, or if we actually want to sort of manipulate or lead them towards a solution. What we always have to remember is that these parties have to be satisfied by the outcome. They might not win 50-50, one might win 80 and the other 20, but what is important is that when they go back, when after a very exhausting mediation meeting, they go back, they have a good night's rest, and the next day that they see the agreement they have made and that they are still happy with that agreement. And I would like to thank you all, and it was really an honor being part of this panel. Thank you very much.
Thanks again, Alex. A big round of applause for everyone. How do we do that? I don't know how to do it in this Zoom. But now to Mr. Gonzalo, please, for the closing remarks.
Yeah, thank you. Yeah, you're right. Yeah, once again, thank you for your inputs to all the speakers, panelists, and participants, and joining today also everyone. Goran, thank you also to you. I think it's your fourth time participating in Southeast Asian seminars, webinars, so you're becoming an expert. Thank you for your help here, and Karin's team, of course. I think the exchange of experience between European Union and ASEAN once again has highlighted the importance as mediation as a practical and efficient tool in IP dispute resolution. Also, I would like to thank, well, of course, the IP different offices and ASEAN Secretariat, and also indeed ASEAN IP Academy for their support and cooperation here. The project, SCOPE IPR, remains committed to working closely with you, and we will promote and we continue to promote effective and accessible solutions in the field of intellectual property. So we look forward to continuing this important exchange of practices and ideas as part of the SCOPE IPR project. And I can already tell you that most likely this year or at the end of the year or maybe next one, but we are actually planning to have another seminar. This time it will be presential. We will keep you posted. Once again, thank you very much.
Thank you all.
Thank you. Thank you very much.
Thanks a lot, everybody.
Bye, Gonzalo.